Hi, I'm Janet O'Sullivan, and I'm going to talk about two fascinating recent cases from the law of contract, both of them from the Court of Appeal, that have come out since the 6th edition of the Law of Contract book went to press. Although they're not immediately connected to each other on similar topics, you'll notice that they both deal with the same theme, which is the tension between freedom of contract and the various protective regimes that allow the courts to interfere in people's freely made contracts. A link to both cases is here on the website. So the first case I want to talk about is West and Ian Finlay and Associates, which fits into the discussion of the unfair terms in consumer contracts legislation in chapter 9 of the book. So Mr. West was a successful banker and his wife was an academic neuroscientist, and they bought a large house in London for £1.7 million. And they wanted to renovate parts of the house, so they entered into a contract with the defendant, who was an architect, for architect services. Once that contract was made, the building job went out to tender, and the main contract to do the work was awarded to a building contractor called Armour. But when the work was completed, it transpired that the work was pretty seriously defective. The lower ground floor of the house was badly affected by damp and required extensive remedial work. Both the defendant, the architect, and the building contractor Armour were in breach of contract and responsible legally for these problems. So far, that's pretty bog standard in building contract cases. But there were two further important facts that I haven't mentioned yet. The first is that the building contractor Armour, had gone bust before the Wests commenced proceedings. So they just sued the defendant architect on his own. Now, normally this would be absolutely no problem at all, because as you know, where two defendants are responsible for the same damage, then the law says that they are jointly and severally liable, and the claimant can choose which one to sue, just sue one of them, and let that one defendant recover a contribution from the other one if the other one's worth suing. So in other words, the common law rules of joint and several liability place the risk of insolvency of one defendant squarely onto the other defendant and not onto the claimants. But the problem was that in this case, there was an unusual clause in the contract between the Wests and the defendant architect that purported to alter the common law default rule about joint and several liability. It was called a net contribution clause, which the court abbreviated throughout the case to an NCC. So here's the crucial wording of the NCC. It says that the architect's liability for loss or damage will be limited to the amount that it is reasonable for the architect to pay in relation to the contractual responsibilities of other consultants, contractors and specialists appointed by you. So the Court of Appeal had to decide two things about this clause. First of all, what does it mean? What's the correct interpretation of the language? Does it cover defaults by the main building contractor? In other words, in this case, Armour, the one that went bust. If it does, then secondly, is it an unfair term and thus unenforceable under the Unfair Terms in Consumer Contracts Regulations 1999? So let's think first of all about the construction question. Well, the judge at first instance had managed to find a way of construing the clause that meant that it didn't purport to cover the liability of the actual main building contractor. But the Court of Appeal disagreed. If you listen again to the wording, I think you'll see why. It says that the architect's liability for loss or damage will be limited to the amount that it is reasonable for the architect to pay in relation to the contractual responsibilities of other consultants, contractors and specialists appointed by you. Well, the Court of Appeal just said Armour was another contractor appointed by you. It's crystal clear. We don't need to rely on the factual matrix or the commercial contextual approach to construction. We don't need to worry about solving ambiguities by recourse to presumptions like contra proferentem. This is just crystal clear. So what it means is that the defendant architect is only liable for a reasonable amount, having regard to his responsibility for the problems and Armour's responsibility for the problems. And the court thought this was analogous to what happens under the Civil Liability Contribution Act, when the court has to decide on a just and equitable apportionment of liability. So, having construed it that way, is it an unfair term under the regulations? Just a reminder that the regulations say a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. The court pointed out various things about the factual background. The clause wasn't drawn directly to the West's attention by the architect, nor was it explained by him. But on the other hand, it was prominently displayed in the contract, and it was pretty clear that the West had actually read it. The court said the language isn't really legal gobbledygook, but on the other hand, it's slightly misleading language if you're a layman, because it refers to the architect being liable for a reasonable amount, which might give the impression of being quite a benign and reasonable clause, when in fact its effect, as in these circumstances, can be quite draconian. So bearing in mind that background, how did the courts apply the regulations? Well, the court accepted that this clause caused an imbalance in the rights of the parties to the detriment of the West, but in the end decided that that imbalance wasn't a significant imbalance. The reason seems to be that this form of words was prevalent in standard forms supplied by the architect's professional body, and it would have been pretty commonplace in this sort of contract. And also slightly more subtly, the fact that the contract was made before the main contractor was selected, and it was the West who'd be doing the selecting. So it's, to a certain extent, fair that they should take the risk of their contractor's financial stability or instability. In any event, the significant imbalance thing didn't really matter ultimately, because the court found that even if there was a significant imbalance, it wasn't contrary to the requirement of good faith. Remember that the wording of the regulations is a bit odd here. It's not entirely clear what has to be contrary to good faith. Is it procedural? Is it that the parties have to have acted contrary to good faith when dealing with the other one? Or is it saying something about the term, that it has to be in some sense substantively not in good faith, which doesn't make a great deal of sense? Well, the approach here was mainly procedural. It was about the conduct of the parties' dealings with each other. And the key fact for the Court of Appeal was that the Wests were sophisticated people who understood what was going on. So although in an ideal world it would be best if the defendant had drawn the clause to their attention and explained it, the Court of Appeal concluded we do not think that factor alone is enough to cause the NCC to fall foul of the fairness requirement in the regulations. You might think this conclusion is understandable on the facts. Wealthy, sophisticated clients who had definitely read the contract and probably appreciated its meaning. But on the other hand, it doesn't augur well for certainty, both for consumers in the future or construction professionals and their insurers. It's a little bit unsettling that the clause was only regarded as fair in this contract because of characteristics of these particular consumers, so that the same clause might be regarded as unfair in other contexts, depending on who the contracting parties are. Homeowners aren't really going to have a great deal of choice but to insure against the risk of being scuppered by one of these clauses. Meanwhile, Mr. and Mrs. West have to go back to court to find out what a reasonable proportion of damages they're going to get from the architect. Now, the second case I want to talk about deals with a very similar point of tension between a desire to uphold freedom of contract and a desire to apply one of the protective regimes based on fairness. It resolves the tension in a different way, however, which you might think is surprising when you take a step back. In the previous case, two members of the public, two consumers, were scuppered by freedom of contract. Whereas here, it's big business that's going to take the benefit of a protective regime. So the second case I want to talk about is Makdessi and Cavendish Square Holdings, which fits into the discussion of penalty clauses in Chapter 18 of the book. So it involves an agreement by the defendant, Mr. Makdessi, to sell the majority of his shares in his Middle East media group of companies to the claimant, Cavendish. And the price was payable in instalments, dealt with by very complicated provisions in the contract. Crucially, the agreement contained a number of restrictive covenants by Mr. Makdessi, whereby he promised not to go into business in competition with the business that he was selling to the claimants. And here's the really crucial bit. The contract provided that any default by him, any breach of those restrictive covenants, would trigger provisions whereby he would no longer be entitled to the outstanding balance of the purchase price. What happened, of course, is that Mr. El Makdessi did breach the restrictive covenant by getting involved in a competing business. So he stood to lose about $44 million, the last chunk of the sale price. Not surprisingly, he alleged that this clause was a penalty and thus unenforceable. Well, the Court of Appeal explored the familiar territory of whether a clause is an enforceable liquidated damages clause or an unenforceable penalty. The traditional approach coming from Lord Dunedin's judgment in Dunlop Pneumatic Tyre, which is that if a clause is a genuine attempt to pre-estimate the loss that a breach is going to cause to the innocent party, then it's an acceptable clause. However, if the sum laid down in the clause is extravagant and unconscionable in amount in comparison with the greatest loss that could conceivably be proved to have followed from the breach, then it will be struck down as a penalty clause. Now, since then, in more recent years, the courts have become more wary about striking down clauses as penalties, particularly in arm's-length commercial transactions. And the focus has shifted a bit to whether there's any commercial justification for the provision, or whether, on the other hand, it was included purely to deter breach of contract. And even then, it's not entirely clear how the test is to be applied. For example, you'll remember the case of Murray and Leisure Play, where there was a difference of opinion in the Court of Appeal. Lady Justice Arden thought what you'd do is ask how much, by way of damages, the claimant would be able to claim under ordinary principles in the absence of the clause, then look at how much the clause provided for and compare the two and see if there's any justification for the discrepancy. The other members of the Court of Appeal, in particular Lord Justice Buxton, thought this was rather too rigid and that it should be a broader inquiry into whether the provision was unconscionable. So, for example, there might very well be good commercial reasons for including a provision that provides for a very large payment greatly in excess of that which would be awarded in ordinary damages. So how did the Court of Appeal tackle this in El Makdessi? Well, they approached the question in two stages. First, Lord Justice Christopher Clark asked whether the clause was a genuine pre-estimate of the claimant's loss and concluded that it definitely wasn't. Secondly, he said that there was no commercial justification for such a clause and struck it out as being a penalty. First of all, why wasn't it a genuine pre-estimate of loss? Well, there are two issues bubbling around here. The first is a sort of company law issue, really, which is that when Mr. El Makdessi competes with the business he's sold, it's the company he sold that suffers the loss, not its shareholders whose shareholding declines in value. If you allowed both, you'd be double counting. And therefore the common law would say, that the claimants suffered no recoverable loss. Secondly, the clause was triggered even for the most trivial defaults by the defendants. So the drafting was such that even a trivial, unsuccessful approach to a competitor that caused no problem at all to the claimants would leave the defendant losing millions and millions of dollars. As the Court of Appeal said, there is no proportionate relationship, even a rough and ready one, between the breach which triggers the operation of the clause and the amount withheld. So that's why it wasn't a genuine pre-estimate of loss. Secondly, the Court of Appeal went on to say there's simply no commercial justification for this massive provision, losing millions of dollars in circumstances where the claimant has no recoverable loss. It can only be an attempt to deter breach. But of course, this is the problematic bit. Because when you think about it, the penalty clause jurisdiction represents a major inroad into freedom of contract and is inherently controversial as a result, particularly where you're dealing with a major commercial contract where the parties were represented, both of them, represented by major city law firms in the negotiation and the drafting of this contract. There's no suggestion that Mr. El Makdessi was in an unequal position from a bargaining power point of view. He was thoroughly well advised in everything that he signed. Now, we might want to help consumers, vulnerable individuals subjected to unconscionable penalty clauses. But we've now got the unfair terms in consumer contract regulations allowing us to do precisely that, where the penalty is unfair. So arguably, we don't need the equitable jurisdiction anymore. After all, I think for me, the nub of this case, and that which the Court of Appeal didn't really get to grips with, is what's actually wrong with a clause whose sole purpose is to deter breach. If that's what the parties intended and agreed, what's wrong with that? After all, we allow the parties freedom to regulate their secondary obligations in all sorts of other respects, exclusion clauses, arbitration clauses, and so on. What's wrong with allowing them to boost up the protection of the performance interest and play down the likelihood of breach? I don't know. I hope that this case goes on appeal to the Supreme Court. I think there's a rumour that it might, in which case maybe we'll have the answers soon. But I hope you found these two cases interesting, and thank you for listening.